Ohazurike. Good morning, Tochukwu.
Good morning, Salamatu. Good morning, Nigerians.
Good morning. Okay, we'll begin by getting your perspective on the latest directive of the AGF to the IGP requesting for security for the 17 members elect in the Edo State House of Assembly.
Thank you very much. I think before anybody could actually look at that letter and speak to it, the best would have been to do a historical background. Then that background will commence from the 17th of June to the 5th of August when the Attorney General issued that letter, and then you can draw a conclusion from that letter. Then what are the issues? The governor of Edo State, in line with the provisions of the Constitution, made a proclamation for the inauguration of the House of Assembly of the state. Now, as people may have had issues with that, his proclamation and the events that happened, the moment that matter was subjected to the jurisdiction of a court and the court made a final pronouncement, it means that any other feelings we have or had were just academic. The position of the law will be the position the court has held. Now, in September 2019, the Federal High Court declared that that proclamation was valid and proper, and there could not be any other proclamation, because some members of the House of Assembly, and indeed the national leadership of the APC then, under which all the members of the House of Assembly, the 24 members of the House of Assembly of Edo State were elected, went to the National Assembly, as a party made a proclamation, went to the National Assembly controlled by their party, and both chambers of the National Assembly asked for another proclamation. But the court said there could be no other proclamation and validated the earlier proclamation. Now, some members of the House of Assembly still refused, even after the court had said, do not make another proclamation. It meant that there would be no other proclamation, at least from that June to June 2023. They refused to go there. Now, in December, having omitted to come to sit for the mandatory number of days they should have sat. Now, Nigerians should know that Section 109, Sub 1F of the Constitution provides that if a member of the House, any person elected as a member of the House of Assembly of any state, fails to sit for no just cause, fails to sit for a particular time, which if you calculate it, now I think it may be best I read the Constitution so that Nigerians will understand this thing very well. Yes, so that we can be very specific. Section 109, Sub 1, Sub F. A member of the House of Assembly shall vacate his seat if, without just cause, he is absent from meetings of the House of Assembly for a period amounting to the aggregate to more than one third of the total number of days during which the House meets in a year. More than one third. Now the question now is, how many days should the House of Assembly of a state meet in a year? Section 104 makes it clear, and it says a House of Assembly shall sit for a period of not less than 181 days in a year. 181 days in a year. Now, one third of 181 is 61. That means if a House of Assembly member, without just cause, absents himself from meetings of the House of Assembly for at least 61 days in a year, he loses his seat. And the Constitution, in order to remove the issue of what is the definition of just cause, how can you arrive at a situation where somebody was removed or was absent for a just cause or not, the Constitution now domiciled the power to define just cause in the Speaker of the House of Assembly of that state. And it says, once you are absent, the interpretation of what the Constitution meant was, once any member is absent, it is without just cause, because you are paid as a House member to be on that seat for every sitting. Now, the Constitution says, once you are absent, it is without just cause, you don't have any reason. But for you now to have a valid reason, the presiding officer, in this context, the Speaker, has to put it in writing and certify that no, he is aware of the reasons for your absence, so it is for just cause. Once the Speaker does that, it means it is for just cause. Section 109 sub 3 of the Constitution is very explicit on this. It says, a member of the House of Assembly shall be deemed to be absent without just cause from a meeting of the House of Assembly unless the person presiding certifies in writing that he is satisfied that the absence of the member from the meeting was for a just cause. So the fact that the presiding officer writes that he is satisfied that he knows the reason means it is for a just cause that you were absent. It won't be counted against you, because the 161 days will be
181 days.
The 61 days of absence that should warrant you to lose your seat is that the presiding officer did not write that he's satisfied. Now, in the context of Edo State, the speaker never wrote that he was satisfied about the reasons. So it was proper that after 61 days, and look at the way the Constitution couched that section 1, a member of the House of Assembly shall vacate his seat. So it means that when that thing happens automatically and the presiding officer did not write to certify, it did not need any other power or authority to make the pronouncement. The Constitution says it is automatic
to declare
that seat vacant. Is the Constitution that declares it vacant. That when this happens, this happens. So when you miss your sitting for 61 days and the presiding officer did not write that he is aware of the reasons why you absented yourself, automatically your seat becomes vacant. It is the declaration of the Constitution. Now, let us proceed. So he declared those seats vacant. 14 seats. 14 seats means that the entire number of the members of the House of Assembly in Edo State became 10. Which the Constitution recognizes that there could be vacancies in the House of Assembly, but it will not invalidate their activities. Now, at the point they were 10, that is the total number of House of Assembly members in that state. So if you want to calculate for every other percentages or fractions that the Constitution requires for certain actions to take place, you will do those percentages and fractions on the total number of 10 and no longer on 24. Because until INEC conducts election to fill in those spaces, there are only 10 members of the House of Assembly of Edo State. From December 4 or thereabout, when those seats were declared vacant. Now, let's fast forward to the letter written by the Attorney General. I have read that letter severally. And I think the Attorney General of the Federation wrote that letter not as a product of legal research or inquest into the activities happening in Edo State, but as a product of the decision of the APC campaign organization in Edo State, which resolved and said to these people, lawyer, write to Attorney General. Attorney General, you now write to IG.
Using
so
your
that
office.
IG, yes, right, you write to Attorney General, not Malami. I didn't call Malami, I said Attorney General, so it's the office that is writing. Lawyer, Idahosa, write to Attorney General. Attorney General will now write to the Inspector General of Police, instructing him to take action so that we will go and inaugurate our people. Now the question is, if you have done all this, product of political considerations, which had nothing constitutional or legal about it, the question is, but there is still a rule about how the meeting of a house is summoned. As at the date these people gathered in the sitting room of the person where they held this meeting. Though I heard Odulampa, sorry, what was his name? Victor Edoro, sorry, he's my friend here, so we all just call him Odulampa. That's his name, as friends. The day he was pronounced as a speaker on his own side, and I said, no, it's not. That's not proper, because at the time that sitting started, there were only 3 members of the House of Assembly of Edo State who went to that venue. Now, 3 members is less than 1/3 of 10. 1/3 of 10 should be 4 in this context. 3 members that were in that venue were only members of the House of Assembly. So even if you want to request as members for a meeting, if the House had adjourned and there are certain reasons why you think the House should meet, certain number of persons should sign, the quorum of the House of Assembly of a state is 1/3 of the number. So they did not form quorum. The Constitution provides for quorum. They did not form a quorum. Now, in that place, look at something they must have done again. That is just that they were just doing politics and nothing constitutional. And what happened was that everybody that was involved in this thing decided to be rascally, decided to look at the Constitution and shred it. And that is why I still believe that it falls on the table of the president, who, in living memory, is the greatest beneficiary of free and fair election in Nigeria. Because if the 2015 election was not free and fair, to the extent it was, he would never have emerged as president. Oshomole is the number 2 person who has greatly benefited from free and fair election. Because even after his election in 2012, and in appreciation of the fact that the election was free and fair, Oshomole went to the president then, Jonathan, and appreciated him and thanked him to high heavens for allowing free and fair elections in Edo State. Otherwise, he would not have emerged. So it is now ironical that these 2 persons who are the greatest beneficiaries of free and fair election in Nigeria are now the 2 persons who are trying to ensure that there are no free and fair elections in Nigeria. Let me tell you something.
Tochukwu, before you tell us that, let me just quickly follow up on, what you said.
Yes.
I was, when I heard about, the allegations that the invasion of the State House of Assembly was based on a directive that was given by the AGF, I was taken aback. And so when the letter emerged, I had to look at the address to be sure that it was actually from the office of the Attorney General's office. Now, let's look at the legality of that directive. What is the legality of the directive, and does this not confirm that the group of 17 were planning to invade the State Assembly as was widely postulated?
What happened in Edo State, courtesy of the letter written by the Attorney General of the Federation, was a coup d'etat. The Constitution is very clear about how you take power of the country or any part of the country. It is not defined by the Attorney General. It is specifically defined by the Constitution of the Federal Republic. So, this action by the Attorney General is a treasonable felony. All the members of the House of Assembly committed were part of it. The Inspector General who gave the directive for his men to move in were all part of it. So, this is just a treasonable act. It was a coup d'etat, and it should not be condoned by any reasonable person in Nigeria.
But do you not also think that the Attorney General's request or directive was based on some sections of the Constitution? Because some have cited Section 101, Section 104, Section 90, and as well as Section 91 of the 1999 Constitution as amended, and of which Section 100 or Section 101 of the Constitution talks about the manner in which the House of Assembly should conduct themselves.
Good. Section 101 of the Constitution allows the House of Assembly to regulate its own proceedings. That's the gravamen of the content of Section 101 of the Constitution. Now the question is, as at the 5th of August, that the Attorney General wrote that letter and made mention of 17 members of the House of Assembly, what did he included in that letter that they needed to be inaugurated? The question is, Mr. Attorney General, at the time you were writing your letter on 5th of August 2020, when were the members you were demanding to be inaugurated? When were they elected? Were they elected over a year ago, or were they elected a week before that, your letter? If they were elected over a year ago, how could the Attorney General write that somebody who had been elected over a year ago, does the office of the Attorney General not know that the House of Assembly of Edo State, in line with the provisions of the Constitution, had brought into effect the provisions of the Constitution as contained in Section 109? He is aware. He cannot claim not to be aware. So when he was writing that letter, he knew what he was doing. He set out to instigate anarchy in Edo State, believing that after all we are federal might to control the security apparatus. So if we do it, any reactions, either we shoot them or we kill them, or let them go to court. How
possible is that claim that the Attorney General, is trying to incite anarchy and violence in Edo State?
When you say to the police, go and give them security cover to get inaugurated and start sitting, the question is, from June 2019, when all houses of assembly of all the 36 states in Nigeria were inaugurated, what was happening in the states? Did the Attorney General ask that question? Because if he had asked that question, the only reason he would have written this would have been that he had come to the conclusion that there was no functional House of Assembly in Edo State. And the question is, could an Attorney General have sat down in his office and a state in his country where his Attorney General is operating for 1 year without a House of Assembly? That's not possible. He knew there was a House of Assembly, but because he had set out to achieve a political aim, he desecrated the sanctity of his office and degenerated to this level. Now, section 93 of the Constitution says, there shall be a clerk of the House of Assembly and such other staff as may be prescribed by a law enacted by the House of Assembly, and the method of appointment of the clerk and other staff of the House shall be prescribed by that law. It means that the only civil servant and the office of a civil servant created in any House of Assembly in Nigeria is that of the clerk of the House of Assembly. So all other civil servants, all other offices in the House of Assembly of any state are created by that House of Assembly. It therefore means that you can come to a particular state and the House of Assembly of that state says, we have a clerk, we don't need to have a deputy. Another can call it assistant clerk. So you can create any office or any person, but the only one created by the Constitution
is the clerk.
Is the office of the clerk and the clerk. Now, play the video again of what happened in that residence where they held their so-called purported inauguration. You will see that the person that performed that function was not the clerk of the House of Assembly. Now again, you will also notice that the Constitution says that the person that should inaugurate the speaker is the clerk of the House of Assembly. I think it is still arguable if whether the clerk can delegate that function to another person. The clerk is the one to inaugurate the House of Assembly speaker. Then every other member is inaugurated by the speaker.
Okay.
But what happened on that day? Somebody who is not the clerk.
The deputy speaker, the deputy clerk.
No. Even if you call deputy clerk and I accept, but there are issues that this is somebody that had already gone on compulsory retirement or something. But even if he was the deputy clerk, the Constitution does not know him. The Constitution clearly states that it is the clerk, that the speaker can only take his oath of office. That is in section 94 of the Constitution. Let's look at it. Let's look at it. Section 94 of the Constitution is clear. And it says, the speaker in section 94 sub 2, the speaker and deputy speaker of a House of Assembly shall declare their assets and liabilities in the manner prescribed by the Constitution, and subsequently take and subscribe to the oath of allegiance and oath of membership prescribed as aforesaid before the clerk of the House of Assembly.
So the clerk remains the only
constant because that's the only person recognized by the Constitution. No, the speaker and the deputy speaker.
Okay.
The clerk. It says before that means for any inauguration to happen of a speaker or deputy speaker, the question of office of the clerk must be asked and answered.
Okay.
So if there is a vacancy in that office, you must fill the office of the clerk, then that clerk can now rightly perform the function. But if you don't fill the office of the clerk of the House of Assembly, you cannot perform that function.
Okay, now how would you describe the action and directive of the Attorney General of the Federation vis-a-vis the action that was taken by the 14 members whose seats were declared vacant sometime last year? They approached the Federal High Court and the matter is still in court, and there is a letter now inaugurating the 7th.
Now, something happens, a decision is taken. I don't have a problem when they were declared, their seats were declared vacant. They did the right thing they were supposed to do. They went to court to challenge that declaration. Now, in the middle of this declaration, somewhere along the line, when the political decisions were taken, they withdrew that matter before these issues happened. Now, because you have subjected it to the jurisdiction of a court, INEC communicated the House of Assembly and said, oh, this matter is sub judice. We cannot conduct any election. Because any election, if INEC had gone ahead to conduct election, would have been declared null and void and would have been voided. Now, INEC said, because of this suit, we cannot do this. And you know that when you go to courts, there is no, and matter is subjected to the jurisdiction of a court. You maintain status quo ante bellum. Status quo ante bellum is the status of things before the quarrel started. Not before you went to court, not before you filed. Before the quarrel, that issue you want the court to determine. That means the status quo ante bellum here means that we were members elect of the House of Assembly before it was declared vacant. So once that court proceeding was still going on, it meant that the status quo will remain, which is they were still members elect. But before they took this step, they went and withdrew that matter. The moment they withdrew that matter, the status quo shifted. It's automatic. It now shifted from status quo antebellum to the declaration of the House of Assembly.
All right, for the
meaning that they were now not members of the House of Assembly and their seats had been declared vacant.
All right, for a lot of time also, there are reports, filtering in that the 17 members elect are planning to have a sit-in on Wednesday, that's this week, and I'm wondering how legal that sit-in would be.
It was a mischievous act by the Office of the Attorney General to write the letter he wrote. If there is anarchy in Edo State, the Attorney General should be held responsible. And I think it is necessary for the president to sit up on this issue. It's a political issue. And the way Nigeria has been painted is whatever is political is more important than any other thing. That is why even when you go to file a matter, however, even if it's about life and death of a citizen, it is not as important to our law as an election issue, because there is a time limit within which it must be determined. So issues of election are more important. Now there's an election coming up, and issues like this have come. And one thing you must know is that Section 5 of the Constitution rests every executive power in the country on the table of the president and the president himself. So if a minister carries out an action, as it means he is carrying out a delegated action on behalf of the president of the Federal Republic of Nigeria. So this letter, until the president says otherwise, is authorized by the president. That's a simple interpretation, because the minister does not have any power on his own, because he's at the mercy of the president. He has a right to wake up and say, I don't like your face anymore. That is the only reason he could sack him and it be valid. So he's at the mercy of the president. So if the president keeps quiet on this issue, it means he has signed off on whatever is happening in Edo State. And Edo State is not as Edo State, no state is easy to govern. The situations are simple. If the people go and resist and you use brute force on them and you kill them, what have you achieved? Can you not, as a president, just say, let us do free and fair election in Edo State? I was gutted. I monitored all the reports in the media after he received the candidate of APC in the villa. The only mandate he gave was that they should go and win Edo State and avoid the issues of Bayelsa, Rivers and Zamfara. The president did not find it worthy to credit one line and give marching order or read the Riot Act and say this election must be free and fair. It was so unfortunate.
Let's talk about the implication of all of this, to consider the fact that the elections are being monitored by the international community, to the extent that the US has expressed concerns over the police interference in the state. Your quick take on that.
Every person can read the constitution of every country and make some little meaning out of it. So that the US has made mention of certain contents, because they know that the constitution of Nigeria is clear, is written in simple English. You didn't need interpretation from anybody in America to understand. And it is clear that what happened in Edo State was an invasion. That's why they said they called it police invasion and interference in political matters. Nigeria is facing serious security challenges. We should not even have time for our security forces to be dissipating energy on issues of election that could ordinarily be settled on a table. And if they do one thing about Nigerians, we obey our leaders. That we don't obey our leaders is sometimes the leaders make us not to obey, ask us not to obey them. If the president says, go and conduct a free and fair election, every person that is involved in this election, I will hold you personally responsible if you fail in your area. All of them will go and do the right thing. But when the president has kept quiet, the implication is that whatever violence, whatever anarchy that this letter from the Attorney General causes in Edo State, Nigerians know where to situate it. Nigerians know who to hold responsible. Nigerians know that what the content of this letter is for the section of the country to be taken over by violence. And Section 99 of the Constitution is clear about the offense of sitting in the House of Assembly when you know and claim that you are in the House of Assembly. So, despite the fact that I do not recognize what they are doing as the sitting of the House of Assembly of Edo State, but if they acknowledge and affirm that what they are doing is a sitting of the House of Assembly, Section 99 of the Constitution is clear that any person who sits or votes in the House of Assembly of a state, knowing or having reasonable grounds for knowing that he is not entitled to do so, commits an offense, and upon conviction shall be sent to prison.
Tochukwu Hazirike, we must go now. Thank you so much always for your perspectives. He's a lawyer and he's been giving us the legality otherwise of the directive of the Attorney General of the Federation to the Inspector General of Police to prevent the breakdown of law and order in the State House of Assembly in Edo State.
All right.